All right, so here we go. Hey there, everybody. My name is Jason Lott. I'm the managing attorney for Trademarks Customer Outreach at the USPTO, which really means that it is my job to teach you about trademarks, what they are, why they're important, and how the federal registration of your trademark can help you build your business. And it sounds like this is a perfect talk for you folks who are here today. All of you are, as Lou said, in education mode. So this is great. This is the perfect time for you to learn a lot of this information, perhaps before you start your business or as you're in your startup phase of your business. So this is what today is going to look like. First, we're going to talk about what in the world trademarks actually are. We're going to talk about why you might want to register with the federal government. We're going to spend a lot of time talking about how to select or choose or create a strong trademark. We're going to talk very briefly about filing and registration. And the reason we're only going to talk so briefly about it is because it's a pretty complex topic and we just don't have enough time today to go into it in depth. But there are a couple of big points that I want you folks to be aware of that you can have at top of mind as you begin to think more about trademarks and what you're going to do with your trademark. And then, of course, we're gonna end with how to find help, some resources that are available here at the USPTO. We also have Julie Mason on the line here from our Silicon Valley regional office for the USPTO, and she can also chime in, of course, with other resources that could be available that she has at her disposal. So let's hop right in and talk about the basics, okay? What in the world actually is a trademark? Well, if you take a look at your screen, you will see examples of pretty well-known trademarks. My guess is most of you can identify all of those trademarks that you see there on the screen. Now, some of you might be wondering, why in the world are they in black and white? Jason, I have never seen these trademarks in black and white. Why did you put them in black and white on the screen? Well, I'll talk more about that in a little bit, but I want to flag it for you. And so just we're going to hang a little lantern there so we can come back to it later on, and we'll have an answer to why in the world these companies have their trademarks here in black and white. But the main reason that I show this slide, and I want you to take a look at these graphics, is because I think it does a very good job of helping us understand exactly what a trademark is. So if you look up in the top left-hand corner there, you see the Apple logo. When you see that Apple logo, what do you think of? Computers, right? Or phones, or watches, or I don't know, TV services, or right? You know, like whatever, like anything that Apple provides, you think of it when you see the Apple logo. Coca-Cola, soft drinks, McDonald's, hamburgers, Amazon, buy anything you want and have it delivered in 2 days. Samsung, personal electronics, consumer electronics. Microsoft, hardware and software. Ford, trucks. Nike, shoes. Google, search, right? So every single time we see or hear or experience a trademark, it automatically calls to mind some very specific goods and services in your mind. And that connection between the trademark and the goods and services is incredibly important because at its very basic level, that is what a trademark is and does. It identifies the source of goods and services. In addition to that, it distinguishes them from the goods and services of another party. And the easiest way to think about it is something you've probably experienced in your own life. You go to a restaurant, you sit down, the waiter comes over, he says, "Would you like something to drink?" And you say, "Yes, I would love a Coke." And he says, "Is a Pepsi okay?" Right? We've all experienced this. And what we've really experienced is a trademark, well, two trademarks in action. You are using the Coca-Cola trademark to identify the source of the soft drinks that you want. And he is using the Pepsi-Cola trademark to identify the source of the goods that they actually provide. And you were both using those trademarks to distinguish the goods and services from each other. Because people who are Coca-Cola people are usually Coca-Cola people, and people who are Pepsi people are Pepsi people. So we all are kind of brand loyal in our own ways, and there are things that we want, and I guess I'll have that. If what I really want isn't available, that's okay, right? So in our everyday lives, we experience trademarks all the time, and we experience how they operate, identifying the source of goods and services and distinguishing them from your competitors. Really what we're talking about is legal protection for your brand. So I want you to think about your business. Maybe you haven't started it yet, or maybe you're in the early stages of getting it going, or maybe you've been stood up for a couple of years now. Whatever the case may be, the trademark, the thing that you use to indicate the source of your goods and services and distinguish them from your competitors, that's your trademark. And that is something that you can protect. So you might want to think about, what is it that customers use to identify me in the marketplace? How do they call for me in the marketplace, right? How do they search for me on Google or Bing or Yahoo or whatever search engine it is that you use? That is going to be your trademark, because that's what people associate with you. And that is something that you can protect through federal registration of your trademark. All right, so now that we know what a trademark is, right? It is indicating the source of your goods and services. Let's talk about what a trademark is not, because there are lots of misunderstandings out there about what a trademark is. So a trademark does not mean that you legally own a word or a phrase, right? Apple has a federal trademark registration on the word Apple. Does Apple own the word Apple? No. Right? So a trademark does not mean that you legally own a word or phrase. And it doesn't mean you can stop other people from using that word or phrase. Like, I can say the word apple, right? Apple can't stop me from saying the word apple, 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 apple. I can say apple as much as I want to, right? So the fact that somebody has a trademark or a trademark registration doesn't mean that you can stop other people from merely saying a word or saying a phrase. It also does not mean that people owe you money if they use a particular word or phrase, right? So if I said apple, 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 does that mean that I owe, Apple 15 cents because it's a nickel every time I say the word apple? No, of course not, right? So as you can see here, a trademark does not mean that you own something. It just, the own a word or phrase, what it means is you have the exclusive right to use it to indicate the source of your very particular goods and services, right? So let's say that Apple has a registered trademark for smartphones. If I invent a new smartphone, could I use the word Apple as the brand name for my new smartphone? No, of course not. So even though Apple doesn't own the word Apple, they do have the exclusive right to use it as a trademark for smartphones and watches and computers and laptops and all the other sorts of things that they do. So hopefully that makes sense. Okay, so a trademark indicates the source of goods and services, and it's very particular about what it does, and it has a very particular function in business. So let's talk about the most common types of trademarks, and this is what people typically think about when they think about trademarks. They think about brand names and slogans and logos. You might have been thinking about some of these things already when you're thinking about, oh, what is my trademark for my business? I mean, what about a tagline? Is that something that I can protect? What if I've hired this graphic designer to help me create a logo for my business? Or maybe your kid is really good at graphic design and you've decided to have your kid design your logo for you. Cool, right? So whatever, these are the things we typically think about when we think about trademarks. And you can see down there at the bottom of your screen, those are pretty well-known examples of common source identifiers for Coca-Cola, right? Brand name, Coca-Cola. Slogan, it's the real thing. And the two images you see there on your right side, those are examples of some of Coca-Cola's logos. You have a composite mark, which is the combination of wording and design, and of course the standalone design mark. So these are the things that we typically think about. But you might be wondering, Jason, why in the world is Coca-Cola in Times New Roman font? Why is that slogan in Times New Roman font? I never see them use that stuff in a Times New Roman font, and you're probably right. They probably don't, right? But that doesn't mean that they can't register it in that way. So what you see there on the bottom of your screen, on the bottom left-hand side there, Coca-Cola and It's the Real Thing. Those are examples of the version of the trademark that Coca-Cola has registered with us. Technically, it's known as a standard character format drawing, right? Standard character format drawing. And what that means is they are not claiming rights to what the wording looks like. They're claiming rights in the wording itself, which might sound a little bit limiting, but it's actually incredibly expansive because it means over the life of the trademark registration, they can use that wording in whatever font style, size, or color they want to. Right? They're not limited to using it in Times New Roman font. That's just kind of the default that the USPTO uses because, well, you have to put it in some sort of font, okay? So really what's happening here is that these brand names and slogans have been registered as the wording itself and giving Coca-Cola flexibility for what those things look like when they're actually using them on an advertisement or on the side of a can or the side of a bottle or on a box or on the delivery truck or wherever it is that Coca-Cola happens to be using those things. All right. And so on the right-hand side, those are, as I said, examples of logos. And you've probably never seen those logos in black and white either. Same thing with the logos on one of the first slides that I showed you. So what's going on here? Well, in this case, what these companies have done is they have registered their trademarks in black and white. That does not mean that they have to use their trademarks in black and white. And in fact, what it means is they can use those trademarks in whatever color they want to. We don't care, right? Because what they have done is registered it in black and white and said, hey, USPTO, I am not claiming any color in my trademark. And we say, cool, that's fine. You can absolutely do that. And what it does is gives you great flexibility over the life of your trademark registration. So you're not tied to it always appearing in a very particular color. So I am not allowed to give you legal advice. All right. So nothing that I'm going to say today is legal advice. However, I can tell you that in all my years of working with small business owners and working as a trademark examining attorney, most often what would happen is a small business owner just getting started, doesn't have a whole lot of money to throw at trademark registration. They would do one of two things. If it's the wording that they're most concerned about protecting, they would apply to register it in standard character format, which means they can use it in whatever font style, size, or color they want to over the life of the trademark registration. Or if they wanted to, if the stylization or the design was important to them, then they would apply to register that trademark in black and white, not in color, because it gave them more flexibility in what colors they wanted to use over the life of the trademark registration. All right, so apply that to your situation. What it is that you're thinking about doing or using as your trademark or trademarks, right? You're not tied to just one trademark. You could have multiple trademarks. And you could even apply to register different versions of your trademark. You know, Coca-Cola, for example, has lots of different versions of the Coca-Cola trademark registered with our office. You are no different. You could do the same in your situation for your particular business. All right, so those are the common source identifiers. I do very briefly want you to take a look at some of the non-traditional types of identifiers, because pretty much anything that indicates source can be a trademark, even sound. Now, I'm not a very good singer, but some of you might recognize the chimes, bum, bum, bum. You might recognize that as NBC. You hear those chimes and you're like, oh yes, that's NBC broadcasting. Right? Or maybe the sound of a lion roaring before a movie begins. That's registered by MGM. It could be a color. So you probably can't tell it based upon the brick down there in the bottom left-hand part of your screen. But way back in the day, before you could actually submit a color drawing of your trademark, you had to line your trademark for color. You might not guess it, but this particular brick is lined for the color pink. And the color pink has been registered as a trademark for fiberglass insulation by Owens Corning. So if you've ever seen hot pink fiberglass insulation, that is a trademark in action right there. You know it's a registered trademark of Owens Corning. If you've ever been lucky enough to receive jewelry or perhaps give jewelry to your significant other, you might have bought it from Tiffany's and maybe it came in this robin's egg blue box. Well, there you go. That's another trademark. But probably the more famous example that we see every day rattling down our streets is a brown panel truck and somebody in a brown uniform, right? The color brown has been registered in those very specific circumstances for parcel delivery services by UPS. You see a brown truck, you know that's UPS. right? So color can also function on its own as a trademark. Down in the bottom right-hand corner there, you see another Coca-Cola bottle. That just goes to show you that you can also register the configuration or three-dimensional shape of something. And in this case, they have registered the three-dimensional contour shape of their bottle. I think it goes back to like 1916 or something like that. So when you see that shape, you automatically know it's a Coca-Cola. Right? You walk into the convenience store, look in the refrigerator case, and you see that shape filled with brown liquid, you know that that is a Coke. Right? So you don't have to have any of these things. I'm not saying that you must. I'm just wanting you to think creatively about your own business and what it is that you're going to have up and going, and what your customers are going to be using to identify you in the marketplace. Maybe it is a particular sound that you have with your whatever it is you're doing, or maybe it's a particular color that you always use. Think about John Deere green, right? The green and yellow color combination on agricultural equipment and lawnmowers and various things like that. Yeah, that triggers something in us as consumers that when we see it, we automatically know the source of those goods and services. Same thing could be true for you. All right. So a knowledge check here. You can feel free to throw this into the chat if you want to. I'm not particularly looking at the chat right now, so I won't know if you got it right or not. So feel free to go ahead and put it in there if you want to. But does a federally registered trademark mean that you own a word or phrase? I'll give you a couple of seconds here to type it in. No, it does not mean that you own a word or phrase. It just means that you have the exclusive right to use that word or phrase to indicate the source of your particular goods and services. All right, one more question for you. And we didn't talk about this, so this is going to be kind of out there. I'm throwing you a little curveball. Do you have to use your business name as your trademark? Oh, yeah, you make you think a little bit here, huh? Do you have to use your business name as your trademark? And the answer here is no. No, you do not. Your business name is just what you use in order to do business, say, in the state of Arizona. It is not necessarily your trademark. That's just giving you permission to do business there. You could have something else that you use as your trademark. If you think about, for example, I don't know, something like Google, for example, they sort of reconfigured themselves and now it's like Alphabet LLC or something like that, right? So Alphabet LLC might be their business name that they register to do business in the state of California, but they use other things as their trademarks, like Google and Gmail and YouTube and things of that sort. So same thing for you. You are not tied to your business name being your trademark. Sometimes business names thought of as a trade name, a company name. People talk about it as a DBA, things like that. Those are totally separate things. They can be the same if you want them to be. So if you want to use your business name as your trademark, sure, you can, but you don't actually have to. All right, so that's the basics of what a trademark is. Now let's talk about why you might want to consider registering your trademark with us, with the federal government. So there are two main ways in the United States that trademark rights are created. One is common law and the other is federal registration. And I'm going to take you through both of these things. So common law trademark rights are created as soon as you begin to use something as a trademark. There you go, right? Nice and simple. You begin to use it, you begin to create rights in it. These rights are generally created under state law, whether it's case law or a statute. But the issue with them is that they are limited to the geographic area in which you are operating. So if you're only operating within a very small area, or maybe you're only going to a farmer's market, right, in whatever town it is that you happen to be in, or whatever city it is that you happen to be in, well, your rights are really going to be limited to that area in which you're operating. Or maybe you're only doing sales within the state of Arizona, right? So your rights would only be limited to the state of Arizona. And that's fine, that's okay, right? If you want to keep your business small, you're not necessarily interested in expanding nationwide or into other states, that's perfectly okay. That's up to you as a business owner for what you want to do. But just be aware that your rights under common law are going to be limited to that area. So it's going to make it a little bit more difficult to enforce those trademark rights, especially if competitors start to come in. They love what you're doing. They love your trademark. They're trying to get a trademark that's kind of similar, right? So it's going to be tougher for you to go after those folks who are potentially infringing on your rights if you're only relying on your common law trademark rights. One thing that you can do, though, is to put people on notice. Hey, I am claiming this as my trademark. You can use the little TM or the little SM. Sometimes you see it, it's off and off to the right side of the trademark, a little tiny TM or a little tiny SM. That stands for TM for trademark, SM for service mark. Don't worry about the distinction between the two of them. Technically, trademark indicates the source of goods, service mark indicates the source of services, but don't worry about it. You can just use TM, and that encompasses both of those things. And there's no rules here about what font you have to use or what size you have to use or where you even place it on the mark. You know, I've seen people place these things on the right side, on the left side, in the center, at the bottom. You know, it's really up to you. Traditionally, however, it's on the right side of the trademark. The one thing you cannot do, however, is use the R in the circle symbol. That is reserved for trademarks that have been registered with us, with the federal government. So it's up to you if you want to put that little TM on there, right? You can start doing that right away if you want to. As soon as you're up and running, as soon as you're using something as a trademark, cool, that's fine. But I can't use that R in the circle yet. That's going to have to wait until you actually register with us if you decide to. All right, so that's common law, right? It's nice and easy. You can immediately start building up rights because that's how rights are created in the United States. They're based upon use. Now you can enhance those rights by federally registering with the government. And these federal registration rights are created when you actually register. And it creates a legal presumption that you are the owner of the trademark and that you have the right to use it throughout the United States and its territories. Now, these are legal presumptions that are created. So you don't have to say, well, Judge, let me give you some evidence here and let me tell you a little story about how I began in a garage, right? You know, no. Instead, you can say, hey, Judge, I got a registration certificate right here. And it creates this presumption that you are the owner of that trademark and that you are the one who has the right to use it, not your competitor. You're putting the public on constructive notice that you are the owner of the trademark, that it is your trademark. Because your trademark would then is published in what is known as the Official Gazette, which is an electronic publication we put out every week of all the different trademarks that have been approved for publication. So you're putting the public on notice. Hey, folks, this is mine. You can bring a legal action concerning your trademark in federal court, which is a great benefit over common law trademark rights, because you can't bring a legal action concerning common law in federal court. You're going to be limited to state court, right? Which means that if you needed to sue somebody all the way up in Wisconsin, well, you would need to go to Wisconsin to sue that person. Not so with a federal trademark registration. Instead, you can file in the federal courthouse nearest you and make that guy in Wisconsin come to Arizona in order to defend against you. You can also record your registration with U.S. Customs and Border Protection, which is a great benefit if you are in an industry where there are a lot of counterfeit goods that might be coming into the country. You can record your registration with CBP, and those agents will work to stop those infringing goods from entering our country at our ports and at our borders. Pretty cool benefit, right? You can also use your application or registration as a basis for filing in another country. So let's say you're doing great work here in the United States and you want to expand into Mexico. You want to expand up into Canada. You want to expand into Central America, South America, and into Europe and Asia and Africa, right? You're going to be global, right? And so you want to be able to protect yourself around the world because trademark rights are country-based. There is no international trademark, right? No worldwide trademark. That's not how it works here on the planet Earth. Instead, you have to get protection in every country that you want to be protected in. So you can use your application or registration here to try and extend protection into other countries. There is a procedure that is in place for that. It's still going to cost money, right? Still got to pay fees and create documents and all that other sort of stuff. But the goal of it is to make it more efficient for you to be able to extend abroad. And of course, the other great thing that you get with federal registration, that means that you're no longer using that TM or the SM, and instead you're using the R in the circle. I've had people ask me before, hey, should I put TM followed by the R in a circle? No, not necessarily, because honestly, the R in the circle is sort of a higher quality, higher value than a TM. So once you have federally registered your trademark, you don't need to put your TM next to your logo anymore. You can actually replace it with that R in a circle. So it is up to you as a trademark owner what you want to do if you want to apply to register your trademark with us. There's no regulation that says that you have to. It's going to be up to you to decide what is best for your business. A lot of times people do decide to do it because they want to prevent their competitors from being able to use a trademark that is very similar to theirs. Or, they spend a lot of time creating that trademark and they want to protect it. Or maybe you've got a big product launch that's coming along and there's going to be a lot of eyeballs looking on whatever it is you're doing, and you want to make sure that your trademark is protected and that people know as soon as they get your product, oh yeah, this is someone who knows what they're doing, right? That's going to be incredibly important if you're talking to investors, or maybe you're talking to a bank and you need to get some financing and you want to be able to use your trademark registration as collateral. Right? It's a property, right? So it's potentially something that could be used as property, as collateral for a loan. And if you think about how valuable trademarks can be, I mean, look, Apple's trademarks, their brand can be valued in the hundreds of billions of dollars. That's a lot of money, right? So if you're looking to get your business up and going, obviously yours is probably not going to be worth as much as Apple's trademarks, but there is a lot of value that can be created in trademarks and can be used to help you grow your business. So a real quick knowledge check. Again, you can throw it in the chat if you want to. No pressure. I'm not looking, okay? So feel free to answer. Are you required to register your trademark with the USPTO? I think I just told you the answer to this one. And the answer is no. You are not required to register your trademark with us. It is up to you if you want to. There is no rule, no requirement that says you have to. You could, if you wanted to, rely your entire business life on your common law trademark rights. It makes your life easier if you federally registered it, but you don't have to. Okay, because sometimes people talk about, well, I've got to register my trademark with the USPTO. I need to go get a trademark or buy a trademark or something from the USPTO. Nope, you don't have to. It is up to you as a business owner if you want to. Next question, and again, feel free to throw it in the chat if you want. Does registering your trademark with the USPTO give you international protection? Yeah, I just talked about this as well. No, it does not. Registering your trademark with the USPTO means that you have trademark protection in the United States and its territories. It does not mean that you have international protection. If you want that protection, you need to file in other countries in order to get protection there. All right, so now that we know what a trademark is, we know why you might want to register your trademark with us, with the USPTO. Let's talk about how to select or choose or create a strong trademark. So a couple of reminders as we dive into this topic, that you are not buying a trademark, you are not getting a trademark, you are not finding a trademark, looking to see if it's available, right? This is not a domain name registry, all right? This is a completely different thing. What you are doing is applying to register your trademark with us. I like to kind of think about it this way. I don't know. Tell me if you think this is a good example or not. All right. You buy. All right. We might have lost recording. It sounds like it might have started again. Okay, sorry about that. So just say you buy a toaster and you might automatically get a 30-day warranty or something like that. And that's fine. You might just rely on your 30-day warranty. If you want additional protection, you got to send in that little postcard, right? Or you got to fill out a form online or whatever, and that's going to get you longer protection, right? So it's kind of similar here. That's one way to kind of think about it, right? If you want that additional protection, you have to apply for it. You got to send in your postcard, all right, in order to get that additional protection. So it is our mission at the USPTO to register trademarks. That is what we are here to do. We would love to be able to register your trademark. However, not every trademark is registrable. There is an examination process that every single trademark application goes through. It doesn't matter if you're a small business owner, you're Coca-Cola, if you're an international conglomerate, it doesn't matter. You're still going through the same process. And there is an examining attorney who will be assigned to your case. That's the job that I used to do. And that examining attorney will take a look at your application and determine whether your trademark can register.
Jason, I'm sorry. Can I interrupt you for a second? When you blanked out there, we lost your slides. So could you reshare them?
Oh, yeah, of course. Here we go. Should be up and running again.
Thank you.
Okay, sounds good. Okay, so let's see, we were somewhere like around here, right? When you apply, the examining attorney is going to be looking at your case and is going to determine whether or not your trademark is registrable. So we're going to talk here in like 2 minutes about two of the main reasons why trademarks are not registrable, because I want you to be able to avoid that situation. But that's what's happening, is this examination process is taking place. And if everything looks good, your trademark will move on to registration. Use that little R in the circle. However, one thing to keep in mind, and this kind of blew my mind when I first realized this, it's that even if your trademark registers, it might not be enforceable. Which I know sounds weird when you think about it. Jason, I spent all this time, all this effort to get my trademark registered. Are you telling me I can't enforce that registration? And the answer is, yeah, maybe, right? And the reason is because of common law trademark rights, because you are not required to register with us. So it is quite possible that there is somebody out there who has never registered their trademark with the USPTO, but because trademark rights in the United States are based upon use and they've been using it for a very long time, they might have very strong trademark rights. And they might be able to assert those trademark rights and essentially cancel your trademark registration with the USPTO. A little scary to think about, right? So you obviously want to avoid that situation. You don't want that to happen. We wouldn't want that to happen. So we always recommend you might want to try and select a trademark that is both federally registrable and legally protectable. And the two things that I'm going to talk about right now are going to hopefully go a long way to helping you have a trademark that is both registrable and protectable. So the first thing we're going to talk about is likelihood of confusion, and it sort of asserts itself in the process through what is known as a likelihood of confusion refusal. That's something that's issued by the examining attorney in your case. And the other thing to think about is the strength of your trademark. And again, this would be a refusal that is issued by the examining attorney and is issued as a descriptiveness refusal. Don't worry, we're going to walk through both of these things, and hopefully you're going to come away with some good pointers and things to think about when you're thinking about what you want to use as your trademark. So first things first, let's talk about likelihood of confusion. The concept here is that we want to avoid having trademarks that are confusingly similar to each other when they're used with related goods and services, right? Because you don't want to walk into a grocery store and you walk over and you see this, cans of Coca-Cola, in the 12 pack or whatever, and it's, COCA-COLA, and you look right next to it and there is QOQA-QOLA. Coca-Cola, right? You're like, oh, are they doing something kind of weird? Like what? I don't know. I guess they're the same, but I'm not really sure, right? That's going to be confusing for us as consumers. And when we're confused about a trademark, that means a trademark is not functioning like a trademark should, because a trademark does what? It indicates source. And when you're confused, it's not really doing a good job of indicating source. And that's because of this other guy, this other Coca-Cola that might be out there confusing us as consumers. So we want to avoid that situation. So the examining attorney, when they get your application, they're going to be looking in our database to find, Is there anybody else in our database that is already using the same or similar trademark for related goods and services? And they're going to apply this test. They're going to ask this two-part question. Are these trademarks confusingly similar? Do they look alike? Do they sound alike? Do they have a similar meaning or a similar commercial impression? And if the answer to this first one is yes, then they move on to the second part of the analysis, which is, are the goods and services related? Right? It's a little bit kind of weird to think about. What does that mean? Relatedness. But what it really boils down to is that we ask the question, are consumers used to seeing one company make or produce both of those types of goods? Or does one company typically provide both of those types of services? If so, those are going to be considered to be related. There isn't necessarily a bright line rule on relatedness. It is always going to be evidence-based. But as a consumer, we're pretty savvy when it comes to these sorts of things. We often know, like, you know what? Typically, two companies don't make that, or one company doesn't make both of those things. So that's the test that the trademark examining attorney is going to apply. And I know some of you are probably thinking in your minds, is it possible, Jason, for there to be two trademarks that are identical and still be okay? And the answer is yes. Yes, absolutely. There are several instances where there are identical trademarks that have been registered with our office. Take, for example, the example of Dove. If I said Dove, probably half of you thought of soap and the other half of you thought of chocolate bars, right? So exact same trademark, but because the goods are unrelated, right? One company typically does not make both soap and chocolate bars, or if they do it under different trademarks. So we as consumers are not used to seeing one trademark and thinking, oh, they probably make soap and they probably also make chocolate bars, right? Not the case. Delta is another great example of that. Delta registered trademark for faucets and plumbing fixtures, also registered for air transportation services. We don't think the same company is making faucets that's also flying you around the country. No, right? We as consumers are not used to that happening in the marketplace. So that's the test that the examining attorney is going to apply. And if these things are true, then the examining attorney will issue a refusal, right? So are the trademarks confusingly similar? And in addition, are those goods and services related? Now, notice that I did not say identical in either case. It's, are they similar and are they related? And one final note here, some of you might have heard of something called international classes. We're going to talk about those in just a couple of seconds. But the question is, if something is in one class and something is in another class, does that mean they can coexist? Not necessarily, because the test is not about whether they're in different classes. It's about whether they're related. For example, clothing is in one class, jewelry is in another, handbags are in another. All those three things are related, even though they're in different classes. And an examining attorney is going to issue a refusal. If you're trying to register, I don't know, Levi's for jewelry, and there's already a Levi's registered for blue jeans and for handbags. Okay, so let's do a real quick test and see where you come down on these things. Feel free to throw it in the chat or not. In this case, the question is there a likelihood of confusion here? We take a look at the trademarks. Is T-Marquee similar to T-Marquee? Yes, right? They sound alike, they look alike. Shoot, you could even say they're identical. So we move on to the second part of the analysis, for the examining attorney here. Are shirts related to pants? Yeah, right? One company typically makes shirts and pants. I mean, Levi's makes shirts and pants, so does Nike, so does Reebok, so does, I don't know, whoever, Guess, Lee, whatever, it doesn't matter, right? The Gap, right? Banana Republic, J. Crew, whatever, who would say, right? They're all making shirts, they're all making pants, okay? So in this case, if you were applying to register T-Marquee for shirts, the examining attorney found T-Marquee for pants, there's gonna be a refusal. All right, so let's change up the hypothetical a little bit here. Throw it in the chat if you want to. You want to register T-Marquee for shirts. The examining attorney finds T-Marquee for pants. Likelihood of confusion here? I'll give you a second to think about it, and then we'll do the analysis. Is T-Marquee similar to T-Marquee? Yes, right? So even though they don't look alike, they sound alike. So we move on to the second part of the analysis. Shirts related to pants? Yes. So in this case, the examining attorney is going to say there's a refusal. You are not allowed to register your trademark. Let me give you one more. In this case, you want to register T marquee for shirts. The examining attorney finds T marquee for golf flags. Likelihood of confusion here? Well, let's do the analysis. Is T marquee similar to T marquee? Yes, right? And so we move on. Are shirts related to golf flags? I don't know, okay? I would have to do some research to find out, which is exactly what the examining attorney is going to have to do. Does one company typically make shirts and golf flags? I don't know, right? We'd have to find out. And that's something that you could do as well if this was your situation. You could do some research to determine, do golf flag companies also make shirts or vice versa? Well, that's something you would want to know because that might affect the analysis of whether you would be able to register or not. Right? This is all part of doing what is known as a clearance search. You're trying to clear the area around your trademark so that you make sure there is nobody else out there use the same or similar trademark for related goods and services. So if you want to do this analysis before you file, which is what we recommend, you can use the Trademark Electronic Search System, which is your way to search our database of applied for and registered trademarks. It is something you can do for free. It's available 24/7. I will warn you right now, it is not the easiest system to use. It was designed about 20 years ago. We're in the process right now of building an upgraded version of TESS, but it's not ready for deployment yet. So, for the foreseeable future, you're still going to continue to use TESS to do your searching. But it is there. It is available. You can look to see, has anybody else applied to register a same or similar trademark for related goods and services? We also recommend that you look online, look in Google, Bing, Yahoo, DuckDuckGo, whatever search engine it is that you prefer, and look at all of them and look to see, is anybody else out there using the same or similar trademark for related goods and services? If all that sounds too complex, you don't want to do it on your own, we would recommend you might want to work with a private trademark attorney, someone who is experienced in trademark law, and you can hire that person to do the search for you. And that person is going to be able to do that likelihood of confusion analysis on all the different sources that person has access to and is able to find. And that attorney can then give you advice on whether or not they think that your trademark would be able to be registered with us. All right, so one last knowledge check before we move on to the next section. Who says there's a likelihood of confusion in this case? Your trademark is X-seed for agricultural seeds. The examining attorney finds X-seed for live plants. Who says that there's a likelihood of confusion here and there would be a refusal? Let's do the analysis. Is X-seed similar to X-seed? Yes. Again, they may not look alike, but they sound very similar. So we move on to the second part of the analysis. Are agricultural seeds related to live plants? Yeah, probably, right? I'm not an expert in this field. Again, I would need to do research, but probably there is a relationship, and one company typically is putting out seeds and they're also putting about live plants. I mean, go to the garden center of your local hardware store, you're probably going to find a company that's doing both of those things. So my guess is in this situation, there would probably be a refusal and you would be unable to register your trademark with us. All right, so that's the likelihood of confusion. Okay, now we're going to move on to the other thing I want you to think about, which is the strength of your trademark. So the concept here is that we are trying to avoid trademarks that essentially fail to function as trademarks because they are not indicating the source of goods and services. And the test that the examining attorney is going to apply is this descriptiveness test and is asking the question, does the trademark merely describe the good or service? Because if it's just merely describing the underlying good or service, it's not really functioning as a trademark because it's not indicating source. It's just telling you what the thing is, right? Think apple pie as a trademark for potpourri. That's telling you that potpourri smells like apple pie, right? So if it's merely descriptive, it's not functional and it might be refused. But let me give you a little graphic here that sometimes helps. So what you're looking at here is my version of the descriptiveness spectrum is what it's typically called. But I like to think about it as a temperature gauge that goes from weak to strong or cold to hot. And you want your trademark to be in the hot range. You want it to be strong. You want it to be fanciful or arbitrary or suggestive. All right, you want to avoid those trademarks that are down in the cold section of the thermometer. Let's talk through those so we can dismiss them right away. So down at the very, very bottom, the coldest sorts of trademarks aren't even trademarks at all. They're just generic terms. It's the common everyday name for the underlying good or service. These things are unregisterable. You cannot register them at our office. An example would be milk for a dairy-based beverage, right? It's not indicating the source of the goods. It's just telling you what the things are. Sometimes people think about, hey, what about Xerox and Kleenex and Google? Well, those are actually not generic because companies work very hard to make sure that they do not become the generic term for something. And those are still registered trademarks. Okay, so please, please, please avoid generic terms. That is just the name of your thing. Look, if you're doing tax preparation services, please do not try and register tax preparation services as your trademark. It is going to be refused. So slightly better and a little bit warmer than generic trademarks are descriptive trademarks. Now, I've already mentioned these, and I said that these are trademarks that directly describe something about the underlying good or service. These two are unregisterable at our office, this time on the principal register. Now, I haven't talked about it at all, but there are two registers at the office. There's the principal register, which is the one that you want to be on, that gives you all those great benefits we've already talked about. And then there's the supplemental register, which really exists for trademarks that are not really trademarks yet. They have capability of being trademarks, but they're not really functioning yet as trademarks. So forget about the supplemental register. You want to be on the principal register. So descriptive trademarks are unregisterable on the principal register, except with a showing of acquired distinctiveness. And that means that the public has come to understand, oh, when I see that trademark, it's not just describing the good, it's actually a brand name. Let me give you an example of that. Creamy Whip for whipped topping. Okay, so Creamy Whip is descriptive of whipped topping because it tells you what? It's whipped and it's creamy, right? So you know right away what the thing is just by looking at the trademark. But in this case, the trademark owner was able to overcome that refusal and register the trademark with us because it is now acquired distinctiveness. When people see Creamy Whip, they think, oh yeah, that's right. That's that brand of whipped topping. So I point this out to show you it is possible to register descriptive trademarks, but you have to jump through a couple of hoops in order to do it. And the question then becomes, how much value do you really get in registering something that is essentially a descriptive trademark? Obviously, you're going to get you're going to get the benefits of the principal register, but it's going to be a pretty small scope of protection, especially when compared to the other things that are on the hotter range of our temperature gauge, such as suggestive trademarks. These suggest a quality of the good or service without actually describing it. All right, so these are registrable at our office, which is good. Let me give you an example to try and send it home here. So copper tone for suntan lotion, right? In Arizona, you probably use suntan lotion a fair bit, right? So copper tone doesn't describe suntan lotion. It suggests that I guess if you use the lotion on your skin and you go out into the sun, your skin will take on a coppery tone, right? So you see all the sort of like leaps and jumps your mind has to make in order to like, oh, I guess if this, great. That sort of thing is fine. It is inherently distinctive as a trademark, and it's going to give you a broader scope of protection than something that is merely descriptive and that is then acquired distinctiveness. Even better than that, even hotter than suggestive trademarks are fanciful trademarks. These are invented words that have no meaning in any language at all. Okay, they're simply made up. They're also referred to as coined trademarks. These are registrable. They are inherently distinctive. These are great. These are strong. An example would be Xerox for photocopiers. Okay, when this first came out, nobody had any idea what Xerox meant. I mean, we know now because we have learned as consumers that when we hear Xerox, we think photocopiers. But it took a while for us to learn as consumers that relationship between the trademark and the underlying good or service. No way does the word Xerox describe a photocopier. These are great. These are really strong. Think Kodak for cameras, Exxon for petroleum, Pepsi for soft drinks, right? Kleenex for facial tissues. There are lots of trademarks that are out there that are fanciful, very, very strong. Also very, very strong are arbitrary trademarks. These are actual words, but they don't have any association with the underlying good or service. Okay, these are registrable. They're inherently distinctive. Best way to look at it is an example. So Apple for computers. Again, Apple, common everyday word, but that word has no relationship whatsoever to computers. It is arbitrary when used with computers. Same thing with Gap for clothing or BlackBerry for a mobile device. All of those are arbitrary when used with the underlying good or service, inherently distinctive, very, very strong. And so again, fanciful and arbitrary trademarks are going to give you an even wider scope of protection than your suggestive and acquired distinctiveness trademarks. And a reason for that is that there are going to be less people who are using fanciful and arbitrary stuff out here, right? So that means you're going to have less competition when it comes to consumers trying to differentiate between your trademark and somebody else's. If you were somehow able to register tax preparation services and somebody else was tax preparers, you'd be like, consumers, like, I don't know the difference between these two, right? Really small scope of protection. But if one was, Zerka-burk, you'd be like, I have no idea what that means, but wow, that's a really strong trademark. I know exactly who those folks are. I'm going to go with their services. All right, so that's the descriptiveness spectrum. You want to be up here at the top, fanciful, arbitrary, suggestive. Think about your trademark or the trademark that you're thinking about using for your business. Where does that fall on the spectrum? Fanciful, arbitrary, suggestive? That's where you want to be. Real quick, as we quickly move on to the next parts of the presentation here, knowledge check. Which one of these would be registrable at our office? Bicycle for bicycles or bicycle for playing cards? I'm sure at this point you already know the answer. Go ahead, feel free to pop it in the chat if you want to. Here, registrable would be bicycle for playing cards because it is what? Arbitrary. That's right. So bicycle for bicycles, that's generic. Not going to work. But bicycle for playing cards, it is. And actually, it's a registered trademark, probably been around for like 100 years now for the US Playing Card Company. So that's how a common everyday word like bicycle can function as a trademark, so long as it is not indicating the source so as long as it's not describing the source of the underlying good or service. All right, I'm going to move quickly through this because I do want to get to your questions. People sometimes ask, what does the filing and registration process look like? It kind of breaks down into these 4 sections. You apply, we examine. There's this weird sort of phase called publication. It's a 30-day opposition period in which your trademark is published in the official gazette. And if all goes well, you move on to registration. That's a very simplified version. There's going to be back and forth with you and the examining attorney. It's going to take time to move through this process, but that's really what it boils down to. You apply, we examine, there's publication, and then hopefully moves on to registration. For those of you thinking about applying, just be aware you're going to apply electronically through our trademark electronic application system. We currently have 2 flavors of TEAS, T-E-A-S, TEAS Plus and TEAS Standard. I'll talk about the differences in just a second. Again, this too, we're working on an upgraded version of the filing system. It's not ready to go yet, but hopefully within the next year or so, it will be. One thing to keep in mind is there are things that you're going to have to put in your application, okay? One is a clear drawing of your trademark. Remember those black and white versions that we looked at like an hour ago? Yeah, that's what's known as a drawing. So it is up to you to decide which version of your trademark you want to apply to register with us. You can apply to register your trademark if it's a brand name in standard characters. Or if the stylization is important, you could apply to register it in stylized. Or if it's a logo or something like that, you could apply to register that. But you probably want to do it in black and white if you want more flexibility. It's going to be up to you. Just remember, 1 trademark version per application, all right? Don't jam a bunch of them in there trying to save on cost, right? So every version that you want to apply to register, that's a separate application. Also, in your application, you've got a drawing. you have to have your goods and services. What are the goods and services that you use with your trademark, right? You got to tell us what those things are. For each good or service that you list, you have to tell us what's the legal basis you have to apply to register your trademark for that good or for that service. It's known as a filing basis. You also have to give us contact information, right? So we know how to get a hold of you. And of course, there's going to be a filing fee. Very briefly, this is what the filing fee looks like. The standard fee is $350 per international class. I know some of you are like, Jason, you said there's no such thing as an international trademark. That is true. I did say that. International class is a little bit different. I'll talk about it in just a second. But the standard fee is $350. However, if you're willing to use the T's Plus version of our form, you're going to get a reduced rate of $250. So $100 off per international class. Which is a pretty good deal. And the reason that we are encouraging you to use T's Plus is we're trying to encourage efficiency. T's Plus is going to require you to put everything in to front load your application, which makes it easier for our examining attorneys because then they don't have to chase you down looking for stuff. You already have it in the application. They can examine it, check, 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 check. Good to go. And actually, we found that folks who file T's Plus are more likely to move quickly through the process. So what's the deal with international class? Okay, very briefly, we have agreements around the world with other countries about how goods and services will be classified. And we have all agreed that they go into 45 different international classes. International classes because they're based upon international agreement. So chemicals go in one, metal goods in another, power tools in one, hand tools in another, vehicles in another, clothing in another, sporting goods in another, and so on, right? And so when you were telling us what goods and services are associated with your trademark, our system in the background is going to be saying, oh, that's class 18, that's class 25, that's class 28. And so when you finish up your application, it is going to tell you what your fee is going to be based upon the number of international classes that happen to appear in your application. It's not based on the number of goods and services. It's based upon the number of international classes that are tied to those goods and services, which in a lot of ways means it's going to be cheaper for you, right? If you're paying per good or per service, ooh, that could get pricey. So it's based upon the class that each of those things might be in. So your filing fee is going to be based on the number of classes that happen to appear. If you don't like the filing fee, no problem. You can remove things from your application and chop it down to $250, right? If you're only applying for things that are in one international class, it's $250. If things are in two, $500, and so on. All right, so we've talked about two reasons why your trademark might be refused registration: likelihood of confusion and mere descriptiveness. There are other reasons such as geographic descriptiveness. Your specimen, your evidence of how you're using your trademark doesn't support use. Maybe your trademark is used in an ornamental manner. Maybe it's primarily merely a surname or a title of a single work, or it's a character name. There are any number of reasons why your trademark could be refused registration. So it's very important that you're aware of all of these things. You want to think through all of them before you apply. I'm not trying to scare you off here. I just want you to have your eyes open, because I don't want you to apply for something and the examining attorney says, no, you can't do it, and here's why. So this is really just a suggestion to make sure you're really looking at this stuff before you fill out the form and pay your money. Just a quick reminder that when you get to registration, if you get to registration, it's going to be up to you to enforce your trademark rights. We are not an enforcement agency, so it's going to be up to you as the trademark owner to enforce. Might be a cease and desist letter, might be a lawsuit. The other thing to remember is that your trademark registration can last forever, so long as you file your post-registration maintenance documents with us. These happen at various set periods. So you have to continue to use your trademark in interstate commerce, and you continue to file your documents with us. It could last forever, right? So you can pass down your business to your kids and your grandkids and your great-grandkids and keep the whole thing going. Another quick reminder that your application information does become public. It's a requirement that we make the information publicly available. It's so people can contact you about your trademark. Hey, boy, I really love your trademark, your concept here. Would you license it to me? Or something like that. Or hey, I want to buy your business. Okay, I'm going to offer you X millions of dollars for it. Yeah, you're probably going to want to get that email, right? Maybe, maybe not. But the drawback to that is that because it's public, that means that anybody can access it. And so there are folks out there that scrape our database and then they send you solicitations. We're all used to getting junk mail in the mail and on our texts and phone calls and all those sorts of things. Unfortunately, it's no different here, and you will get things that are solicitations. Folks trying to trick you into paying money that you do not need to pay. They are pretending to be the USPTO. They are not the USPTO. So please be very aware. If you apply, you are more than likely going to get some sort of solicitation from one, if not more, of these companies. All right, I know we need to move on towards questions, but real quick, are you guaranteed registration of your trademark? I think you all know the answer, and it's no, you are not. Your trademark is going to be examined before it can move to registration. You have an opportunity to overcome the refusal, but you're not guaranteed registration. And also, if it registers, do you have to do anything to keep your registration alive? And of course, as I just mentioned, the answer is yes. Yes, you do. You have to continue to use it in interstate commerce and file your documents with us. All right, I'm going to blow through the help section and then we'll get to your questions. We have lots of great resources available on the website. We have videos. We have our new Trademark Basics Registration Toolkit, which is really kind of a condensed version of a lot of information into a PDF that you can download, and you can keep it close to you on your computer, on your phone, whatever you want, and sort of walks you through some of the main things you need to know about the process. If you like this stuff, and if you don't mind me too much, I'd encourage you to sign up for a Trademark Basics Bootcamp. This is free. It is an 8-week course. Takes place on Tuesdays at 2 p.m. Eastern. We start our next cycle on October 4th. So you have plenty of time to sign up for it. You can sign up for as many or as few as you want. The first week is going to be a lot of the same things we talked about today, and then we go in depth on all those things that I skipped over because they were too complex to talk about. And so I take you through the registration process. I even take you into tests, show you how to search in tests. I even do a walkthrough of our T's Plus form. You can see how the form is filled out. So we've had lots of folks take it over the past couple of years. Thousands of people. It seems to really go well. People seem to like the information that's in there. So I'd encourage you, if you're interested, to sign up and join us for boot camp. We have lots of free services and resources available through the USPTO, not just trademarks, but patents as well. So if you're interested in patent information, obviously, that's not something I talk about today. It's not my area of expertise, but we have lots of great patent resources as well. Use the link you see at the top of your screen there. Also recommend the Trademark Law School, the Law School Clinic program. If you want help from an attorney, you can't necessarily afford it. You can apply to become a client of one of the clinics. There are over 60 of them across the United States, and you will get help from a trademark attorney and some law students for free. So I would encourage you to check that out if it's interesting to you. If you have general trademark questions, you can contact the Trademark Assistance Center. They're our customer service folks, always happy to help you. They're open Monday through Friday, 8:30 a.m. to 8 p.m. Eastern. They pick up the phone very quickly. So if you want to talk to a human and get some general trademark information, these are your folks. Be sure to give them a call or shoot them an email. Just remember that they cannot provide legal advice. And I cannot provide legal advice. Julie cannot provide legal advice. No one on the call today from the USPTO can provide legal advice. We also cannot provide or recommend a specific attorney to help you out. All right, I know I was moving very fast there towards the end, but I do want to get to your questions. So I'm going to stop sharing my screen here, and let's talk through any questions that might have popped up over the last hour and 11 minutes. What do we have, Lou? Anything good come in?
Can you see the Q&A?
Oh yeah, give me 1 second here.
Just curious.
Oh yeah, here we go. Okay, let's see here. We have a question from Mark. In my case, I'm choosing a name to trademark in real estate. So for example, if there is a trademark for real estate, does that mean that no one else can use the word real in front of real estate, even if there is more to the name? That's a great question, Mark. So keep in mind, I cannot give specific answers, right? So I cannot tell you that, yes, that one's good to go, and here's what that means, right? Because remember, that likelihood of confusion analysis always boils down to comparisons, right? We get it, real estate, those are similar. So let's talk about the similarity of the trademarks. just because the word real is in there, that does not necessarily mean that it is going to block all other real trademarks that come along, because the analysis is based upon what is the commercial impression, right? What is the meaning that is created by each of these trademarks? So it might be that another trademark that has the word real in it and also some other wording creates a completely different commercial impression than another trademark that has the word real in it. Okay, so I cannot make any guarantees. If this is a specific situation that you are particularly involved in, please note, I am not saying one thing or the other. I'm just trying to give general information about it. In general, just because a word is there, it does not mean it blocks all other trademarks that have that same word in it, even if it's in the same field. It really is going to boil down to the commercial impression that is created by both of those trademarks. That's an excellent question. Just keep in mind, there's no bright line rule when it comes to these sorts of things. It's not a formula. If A, then B, that's not it, right? There's a lot of art and there's a lot of science that kind of goes into clearance searching and determining whether there is a likelihood of confusion. That's a really great question. Thanks for asking it. If you have any follow-up, feel free to pop it into the Q&A.
Hey, we had one more come into the chat, Jason.
Okay.
Does Matthew Conaway, does slang increase the uniqueness of descriptive trademark in the application process?
Does slang increase? Interesting question. Let me see if I can find it. Let me look at it, because I'm better. I'm a better visual person.
Okay, you could see it.
Is it towards the end?
Yeah, towards the end in the chat.
Does slang increase the uniqueness of a descriptive trademark in the application process? Oh, cool. Great question. So it's going to depend really on perhaps how known the slang is, right? If it is a slang word that you came up with and nobody else uses it, just you and your buddies, then probably that could maybe, right? But if it's a slang term that everybody uses, everybody knows the descriptive, what it really kind of means, then it's not necessarily going to help you. Alternate spellings, misspellings of descriptive words, that doesn't overcome it. Using a Z instead of an S, right? That's not necessarily going to overcome it. A refusal, because there is no one correct spelling of a trademark. There's no one correct way to pronounce a trademark. So, look, if it's descriptive, no matter how you spell it, it's probably going to be refused. So slang is obviously a different sort of situation where in some ways you're kind of translated it into another language a little bit. But as long as it's not a sort of like known slang word for that thing, it could be something that's okay. Again, sorry, I can't give you a specific legal advice on whether or not it would be registrable. But in general, if it's known slang, that's not going to necessarily help you overcome the descriptiveness. All right, what else do we have? Looks like some more things coming in the Q&A. Anonymous attendee, thank you for attending. A trademark I've considered, 2 words without a space, is the same name as a business in another country and industry, but theirs is 2 separate words. Is that too similar? Okay, so a couple things going on here. We'll try and break it down. So if you have one trademark that is like jammed together, right, sort of condensed, 2 words condensed down into one, and another that is 2 words with a space, the addition or deletion of a space doesn't affect the analysis at all, right? Unless it somehow creates a different commercial impression. But for the most part, the addition or deletion of a space or a hyphen or something like that isn't going to change the analysis of whether or not 2 trademarks are similar. So then we move on to the second part about relatedness. You're saying that these are essentially operating in 2 unrelated industries, or at least different industries. Well, in that case, there's a pretty strong possibility that these would be considered to be unrelated, right? If it's, let's say it's, Jason's Best, all one word, for automobile tires, and Jason's Space Best for, I don't know, rubber garden hoses. I don't know, maybe there's relatedness there because they're both made out of rubber. I don't know. But in general, a company that makes automobile tires is not necessarily going to be also making hoses. So, without very strong trademarks, there's, could be a strong possibility that those would be unrelated and those would be able to go ahead and register. The other additional element here is you're talking about a business in another country. Remember, trademark rights are country-based. So the fact that somebody else in another country is, using something, it doesn't necessarily block you here in the United States because trademark rights are country-based. Now, I'm not suggesting that you immediately run out and start trying to register the trademarks of other companies in other countries, because remember, in order to register here in the United States, it has to be based upon use, right? And so you have to be very careful about that. And we can't have any sort of trademark squatters that are out there like folks used to do in the early days of the internet, cyber squatting on various domain names and things of that sort. So remember, trademark rights are based upon use. So as long as it's a legitimate use and the other business doesn't have any operations in the United States, you might be okay. But it's certainly good that you have flagged it as a potential problem. And my suggestion would probably be to talk to an experienced trademark attorney, somebody that you hire, a private practice attorney, to help you look into it. Because even if you think it's going to be fine, that attorney might be able to help you understand or be able to find some information that you didn't have access to, that, oh, you know what, even though they're based in another country, they are operating in the United States or something like that. You don't want to run into a situation where all of a sudden you get entangled with a fight with another business. And it can happen. Okay, so just be aware. You might want to think about talking to an attorney in that case. Let's see. What does the post-registration filing process entail? Is it a yearly submission? Great question, Melissa. It's actually fairly simple. It is not a yearly submission. Here's the easy way to think about it. Every 10 years after registration, you have a document that's due. It's called a combined Section 8 and 9. So in general, every 10 years. There's one little outlier, and that's between the 5th and 6th years after registration, you have the Section 8 that is due. So between 5 and 6 years after registration, you got a document. 10 years, you got a document. 20 years, document. 30 years, document, and so on, right? So not yearly. It's pretty straightforward. The form, the Section 8 that you have to fill out essentially says, yes, I am continuing to use my trademark in interstate commerce. Here is another specimen that shows you how I am using it in interstate commerce. Here's my filing fee, and that's pretty much it. All right. Now that at that time, you should also be deleting things from your registration that you are no longer deleting goods and services that you are no longer using with your trademark. And the reason I note that is because people have not been good about that. And so there is a lot of what we call dead wood on our register, which means that somebody still has something registered, even though they're not still using it as a trademark. And what do we know about trademark rights in the United States? They're based upon use. So if you're not using it as a trademark anymore for particular goods and services, it shouldn't be registered for those. Yeah, maybe it's great. You got Uncle Charlie's, trademark, that registration from 1947, and you want to keep that thing alive. Yeah, but if you're still not using that trademark, it should not still be registered. And, old Uncle Charlie's trademark should be available for other people to use or to register something similar, something like that. So the process itself is pretty straightforward, pretty simple, but you just want to be aware that everything you're saying in your Section 8 filing is true. Okay, let's see what's next. Is it smarter to hire an attorney to see how feasible a name is at getting accepted, or just submitting for the trademark? My personal recommendation would be to hire an attorney because the last thing that you want to do is submit an application, have to wait months and months in order to get that refusal. All right. You want to know in advance. And so you can do that clearance search. If you don't feel comfortable doing it on your own, you might want to hire an attorney to do that search for you. And that attorney can give you advice before you file and say, you know what, this one, I would avoid that one. This one, probably okay. This one looks great. This one looks great. That one, not so much. right? Have that attorney do a search on a couple of trademarks that you're considering and figure out one that is going to have the best chance of being registered. Are there any laws to review if the business owner moves to another US state? I don't have an answer to that. That's kind of outside my wheelhouse. Laws to review if the business owner moves to another US state. Anonymous attendee, I'm not exactly sure what you're asking there. I don't think it's something I can answer, but if you can give me a little follow-up on that, let me know. I'll see what I can do. Another anonymous attendee, or maybe the same one. Are there any special considerations for trying to trademark text or characters in a different language or multiple languages in one name? Yeah, so if you are applying to register a word or more than one word that is in a foreign language, then you will have to tell us what that language is and what the translation is. Right, so please don't try and get around a descriptiveness refusal by applying to register that descriptive word in another language. It's gonna get refused, okay? So there's something that's referred to as foreign equivalence. So if something is equivalent in another language, it's gonna get a refusal. That is gonna apply to a descriptiveness situation. Same thing with likelihood of confusion. Let's say that you wanna register Fiesta for, party plates. But already registered is party for party plates for some reason. Well, fiesta means party, right? In Spanish, they're going to get refused because they have the same meaning. Okay, so that's certainly some special considerations there. If it's a trademark that's in a foreign language, it could get refused if we treat it as if it were English. Gloria says, I only recall a fee structure slide regarding international trademarks. Was there one that I missed? No, actually, Gloria, that was not about international trademarks. This is where it gets very confusing, and I apologize for that. Sometimes the words are confusing that way. The fee structure slide was actually US prices, but the fee is based upon the international class or the number of international classes that are included in an application. So it's not, again, about international registration. It's just that we have agreed internationally that goods and services are classified into these 45 different international classes. Great question. Melissa, if you get a refusal with a national registry, can you still use your name or logo in your state? Great question. Yes, just because the USPTO says you may not register with us, it does not mean you have to stop using your trademark. Okay, we do not determine whether or not you have the right to use a trademark. We only determine whether you have the right to register your trademark with us. So if you apply to register, tax preparation services for your tax preparation services, and we say, no, that is generic, you may not register with us, and you can say, cool, I'm going to go ahead and use it anyway. You are more than welcome to do that. We're not gonna stop you and say, hey man, you can't do that. Nope, it's up to you. Now, granted, you're not going to have a very large scope of protection because everybody who does tax preparation services is going to want to be able to use tax preparation services to describe what they do, or maybe as part of their trademark. So it may be very difficult for you to defend that as a trademark. But just because we say you may not register with us, that does not mean that you have to stop using your trademark. Excellent question, Melissa. Anything else, Lou, that you've seen here that I've missed that maybe came in to the chat?
No, I don't see anything else. That was terrific, Jason, and thank you very much. Yeah, I mean, this is the second year I've gone through it, and every time I think I know what I need to know about trademarks, I listen to you and I learn a lot of other stuff. So I really appreciate it. I don't think I can get the slides back. I don't know where Eileen is, but that's okay. I can close our session here.
I can give you the host permission.
Okay, thank you, Eileen. Share screen.
And Lou, as you're bringing it up, just so you know, I'm learning new stuff every day myself. There's always something that I'm learning too, and I've been doing this for over 20 years. So not a surprise that we're always like learning things to help us fill out our knowledge base.
Yeah, absolutely. So we've gone through the questions. I just want to close, on the attorneys, I will tell you, I often refer my clients. I don't have the depth of knowledge to advise, of course, on intellectual property in detail, but we are allowed at the SBDCs to provide local resource referrals to our clients. We maintain lists of people that we know in the community that are good and competent. There's no financial incentive for us. We're required by our charter and our grant to give you at least 2 or 3, so you can kind of make the choice. But so if anybody does need attorney referrals locally here, you can contact us, and I'd be happy to do that for you. So again, if you need SBDC counseling, or you like counseling, you've got an invention, you've got a business, you've many of the things we talked about with regard to intellectual property, you can request counseling at this link. And again, you'll get these slides afterwards, so you'll see the link. It is by appointment only. We do an initial session. It's an intake session. We get to learn all about you. You get to learn a little bit more about us. Then it kind of turns into, if we've got a match and we want to work together, we have these follow-on sessions. And I've got clients, I've been here for 3 years. I've got clients I've had for 3 years. I know in the SBDC, we have counselors who have clients for 10 years, who have, grown significantly. So we can help you all the way through. And then, we do track your business goals. That's part of our charter. Our charter is economic growth. That's why we're here. Economic growth means that you are selling more, hiring more, injecting more capital when you need to. And we track those, and it's reportable to the SBA. That's how they know we are doing our jobs. And so we're very focused on growth here. So again, come see us at the SBDC here at Maricopa. If you're not in Maricopa, you can Google SBDC. If you're in another state, there's local resources. They're pretty easy to find, as well as others here in Arizona. So that's all I have. Eileen, do you have anything? No. Okay.
No, that will be all.
That'll be all. Will a survey go out, Eileen?
Yes, a survey will be going out after our webinar.
Okay. Yeah, please fill out the survey and help us make these webinars better. We really value your feedback. So again, Jason, thanks again. I certainly appreciate it. And I look forward to our next one.
That sounds great. Looking forward to it as well. Thanks for the invitation. Appreciate it.
Okay,
Thank you,
thanks.
everyone.
Okay.
Okay. Bye-bye.
Bye-bye.